A Dartmouth volleyball coach made headlines this week when he was charged with sexual assault and producing and distributing child pornography. The Chronicle Herald reports that Joseph-Émile Luc Potvin faced similar charges in 1999, but they were dismissed. And he was pardoned after a conviction, but it is not clear what the conviction was for. Yesterday, the Halifax Regional School Board revealed that Prince Andrew High School, where Potvin coached, didn't check for a criminal record or whether he was on the child abuse registry. We asked Sports Nova Scotia CEO Jamie Ferguson what its policy is on background checks for coaches.
For provincial sport organizations, there would be a set of policies. There might be different ones in different community sport organizations. But each provincial sport organization essentially is responsible as its own legal entity to develop and implement its own policies. My experience in the discussions I've had with different provincial sport organizations is that there are most organizations out there employing these criminal record checks as part of their normal procedures, and we certainly encourage them to do so.
That was Sport Nova Scotia CEO Jamie Ferguson. We were surprised to hear that there is no blanket policy requiring criminal record checks, so we contacted John McKiggan to ask his thoughts. He's a lawyer who has represented many childhood victims of sexual abuse.
Having higher levels of screening, in other words, criminal records checks, checking previous references, that higher level of screening may scare off some volunteers, and there are certain organizations that they're struggling to keep the volunteers that they have. That being said, we as a society recognize that it is everyone's obligation to protect the vulnerable, to protect our children.
Are there any specific legal issues in this type of case?
Well, in any claim or litigation involving criminal wrongdoing by an employee or a volunteer, there's two legal issues that come up. Vicarious liability, that means the employer is responsible for the acts of the employee, even if they didn't know what the employee was doing. And direct liability, and that's where the employer itself did something wrong. So in cases of sexual abuse by an employee or a volunteer, the court will look at whether or not the organization should be held vicariously liable, even if they didn't do anything wrong, or whether they will be held directly liable. In other words, they did do something wrong because they failed to adequately screen, or that they knew of information that would put children in danger and hired them anyway. So there's two different issues that the court will examine in these types of cases.
If you were litigating a case and there hadn't been any sort of background check, how do you think that would end?
Well, if you look at what most organizations, volunteer organizations, do these days, it is now very common to see organizations requesting that their volunteers participate in criminal records checks. It's almost universal that employees are required to participate in criminal records checks. There is certainly a higher level of scrutiny required of an employee than a volunteer. So if there is an organization or an employer who has people in a position of authority over vulnerable people or children, one has to seriously question whether or not adequate safeguards are in place if they're not doing something as simple as requesting a criminal records check.
John McKiggan is a lawyer with Arnold Pizzo McKiggan, which specializes in cases of child sexual abuse. He was speaking with Information Morning's Jerry West.